Good evening. This is the News Hour with Mary Beth McLean, and I am Mary Beth McLean. Today we will be discussing the upcoming court case of the District of Columbia versus Dick Heller. For the first time in 70 years, the Supreme Court is hearing a case regarding the intent of the Second Amendment and its association with gun control laws. In February of 2003, 6 residents of Washington, D.C. filed a lawsuit in the District Court of the District of Columbia questioning the constitutionality of the Firearms Controls Regulations Act of 1975, claiming that the regulations violated their Second Amendment right to bear arms. Here to discuss some of the details of the case is our Supreme Court expert, Cathleen Miles. Good evening, Kathleen.
Good evening.
Kathleen, can you tell me exactly how this case began?
Well, in 2002, a man by the name of Robert Levy began gathering plaintiffs for a lawsuit which he was creating and personally financing concerning the Second Amendment. He obviously wanted a group that was diverse in terms of age, race, and economic background, so he picked 6 men, none of whom had previously known each other.
Why was Levy so interested in creating this case?
Well, Levy, a man who had never owned a gun himself, knew the level of controversy surrounding the issue and wanted to bring it before the Supreme Court. Matters regarding the interpretation of the Supreme Court, especially in such hot-button areas as firearms, are always able to bring out differing views.
Yes, people would definitely say that it is the case. And here joining us to discuss the issue is constitutional law professor Kamykowski from Georgetown University. Professor, the Second Amendment states, a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. The precise wording of the amendment has been the genesis for the argument surrounding it.
Yes, that is true. The way one interprets the amendment may vary greatly and undoubtedly cause distinct differing viewpoints. In this case, the question, as the Constitution is applied, is whether the Washington, D.C. Code, which bars the registration of handguns along with a litany of other obscure requirements and regulations, violates the D.C. residents' Second Amendment rights.
The next question becomes, how did the justices interpret this amendment, as it is their job to interpret the Constitution?
Well, Kathleen, there are 2 main views here. There's the stricter interpretation, which holds the belief that only members of the militia may hold firearms, and then there's the looser interpretation in which any citizen may hold a firearm for personal use, such as self-defense.
According to my predictions, we seem to be looking at most of the justices siding with Heller. This is because a majority of the justices are known to have conservative leanings, which may very well influence their decision.
Thank you, Kathleen. Now let's hear a little from some of the justices on this case. Joining us is Justice Mikey Wojnar. Your Honor, what are your expectations for this case, or what can you tell us about it?
All I gotta say is, even though it was predicted that the case would go in favor of gun control and a more conservative outlook, and even though I'm conservative, I actually side with the more liberals on this case, so I think it's a wild card right now, so I don't think you can make any predictions. And that's all I gotta say.
Thank you, Justice Mikey.
Yeah.
We were also able to track down Attorney Joseph Kirchhoff. So, Attorney Kirchhoff, what can you tell me about this case?
No comment.
In the district court, the lawsuit was dismissed. On appeal, however, the United States Court of Appeals reversed the dismissal in a 2-1 decision as the appellate court struck down provisions of the Firearms Control Act on the grounds that they were unconstitutional.
This is true. So, the court concluded that of the 6 original plaintiffs, only Dick Heller had standing for a case because he had applied for a handgun permit and had been denied. The court held that the Second Amendment does protect a person's right to bear arms.
They did. But there were other complications, correct, Professor?
Correct. As Judge Henderson stated in his dissent, there can be no question that the Constitution and all other applicable statutes agree that the District of Columbia is not a state within the meaning of the Second Amendment. Also, it had been previously decided that the Second Amendment was in regard to militias only.
Thank you, Molly. So any last comments on what we can expect when the Supreme Court convenes?
I believe we should all expect to hear a well-argued case from both sides, accompanied by scholarly and intelligent viewpoints and interpretation.
Thank you, Kathleen, and thank you to all our guests tonight. Kathleen Miles, our Supreme Court expert, Professor Kamykowski from Georgetown University, Justice Mikey Wojnar, and Attorney Joe Kirchhoff. I am Mary Beth McLean, and this has been the News Hour with Mary Beth McLean. Thank you for watching.